Greetings, everyone, and welcome to the Golden 30 series. My name is Carrie Gray, and I am the Adult and Senior Services Specialist for Prince George's County Memorial Library System. Today on the Golden 30, we will discuss estate planning with Tony Pasciuto of Byrd and Byrd Attorneys at Law. And now I just want to give a disclaimer that this presentation is for general information only and is not intended to establish an attorney-client relationship and or to give legal advice. Now, with that in mind, let me tell you a little bit about Byrd and Byrd Law Firm. They're not just good lawyers, they are good counsel. Please call to schedule an appointment with one of the experienced and knowledgeable attorneys if you are interested. Byrd and Byrd um, LLC Attorneys at Law are located at 14300 Gallant Flocks Lane, Suite 102, Bowie, Maryland, 20715. You can call or text them at 301-464-7448. And you can reach them at byrdandbyrd.com. Now, let me tell you a little bit about our presenter today. R. Anthony Pasciuto, known as Tony, focuses his practice on elder law and estate planning and joined Byrd and Byrd in 2017. He received his Bachelor of Arts from University of Maryland, College Park, followed by his Juris Doctorate from the University of Baltimore School of Law in 2009. Tony clerked for the Honorable Nicholas E. Rattle in the Circuit Court for Prince George's County. After his clerkship, he worked as an assistant public defender in Charles County, Maryland, handling a varied caseload of misdemeanor criminal, traffic, juvenile, and felony cases. Following his experience in the criminal practice, Tony entered civil litigation where he focused on obtaining benefits for injured workers before the Maryland's Workmen's Compensation Commission and protecting creditors' rights and other breach of contract debt collection cases in the both district and circuit courts. So, wow. Thank you, Tony, for
Thank
joining
you so
us
much for
today.
having me, Carrie Ann. I appreciate being here.
No problem, no problem. So we definitely, today we are discussing estate planning and the importance of estate planning. So let's just start with a little question and answer.
Okay.
So tell me, why do I need 5 documents for my estate plan? Or what are the 5 documents we need?
Sure. So, a lot of times when we talk about estate planning, we talk about different stages of estate planning, both during your lifetime, in case something happens to you and you're incapacitated in some way, and how to handle your property and your estate after you have passed away. The 5 documents we normally recommend is having a good last will and testament. Sometimes that can be replaced by a trust if that's appropriate for you. Having a healthcare proxy or a healthcare power of attorney. Oftentimes, many lawyers will draft that with what's referred to as an advance directive or a living will, but technically they are two separate documents. Having a good, durable general power of attorney, frequently called the financial power of attorney. And then a relatively new concept is the digital diary. And the way that these different items work is with the will, that is essentially giving your instructions for how you want your property divided after you have passed away. With the healthcare proxy and advance directive, a good way to think about it is naming someone to make healthcare decisions for you if you are incapacitated and leaving them some instruction in that living will about how you want that healthcare to be carried out. For the durable general power of attorney, it's simply saying, I am trusting this person to handle my affairs and giving them legal authority to manage my property, manage my checking account, doing those different types of things. And that digital diary is really a tool for that financial power of attorney. So they have the ability to control your Facebook account, your email account, dealing with any other financial things you may be doing online, and having them have an effective means for doing so. And it's really important that all of us as adults, we don't want to talk about these things. It's not fun to talk about getting sick or dying or any of these things, but really being responsible to ourselves and to our family members to put a good plan in place.
Thank you for that. And I think that that's important to include the digital diary. A lot of us don't think about like the digital trail that we leave behind and with all the social media and what's to become of those accounts. Do we still want that information out there? So I definitely think that that's definitely a new add-on that's needed. Thank you for that information. N-
Absolutely.
Now, what happens if I die without a will or a power of attorney?
Sure. So lots of people die without having a will or a trust, and some people joke that they're gone and they don't worry about it anymore. It's up to their family to take care of those things. But what happens is if you own property that is solely in your name, meaning you don't have a joint owner on it, you don't have a direct beneficiary on it, those assets, those bank accounts, the real property, the house, the condo, whatever it is, those things are then forced to go through probate. And there are laws in place in the state of Maryland and just about everywhere else in the country called laws of intestacy that say this is how we are going to divide a person who's no longer with us, divide their assets. And for some people, that's okay, but it really is important to understand what that means. And some people are surprised to know that their children don't have an absolute right to inherit in those laws. It's actually the spouse that has the only absolute right to inherit. And just because every family is a little bit messy, we all have those things going on, making sure you have your will to provide for the family members you intend to, and not really thinking about, well, something might end up in cousin so-and-so's possession or aunt so-and-so's possession who ruined every family cookout or something like that. Thinking about those things, understanding how intestacy might apply, and then really making it go a lot more smoothly with a will is just really the best bet. When people don't have a will, you'd be surprised the number of families we come in that fight over nonsense. And it really isn't necessarily about the value of an item. It's about the emotions behind it. One of the attorneys in the office, he has two individuals who are really fighting over some old junk, an old Bose radio that doesn't work anymore, and some figurines and statues. It doesn't have real financial value, but it's important to them because of how they viewed their relationship with their mom. And certainly their mom never would have wanted them fighting over those things. And if she had done a will to really provide some clarity, she likely could have avoided that fight between her children. When we talk about the powers of attorney, that will that we've just talked about, and you asked about dying after if you don't have a will, the other side of things is during someone's lifetime, and that is when those powers of attorney are truly important. If my mom, who lives in the county here in Bowie, if she were to take ill and get sick and she didn't have a power of attorney, either my sister or myself or maybe another family member would have to go to court and ask the court to appoint us guardian. And I joke a lot about my family. I use them as examples in all of these types of discussions. But my sister is the very sweet, responsible, nice kid. And everybody who knows my family would say my sister would be the responsible one to take care of mom. Well, I like to say I'm the fun kid, right? I like to have a good time. But certainly, if we had to go petition for the guardian of my mom, of either over her person to make the medical decisions or over her property to handle her finances, I like to think I'm a pretty good lawyer. Maybe I could go into court and convince a judge that I should really be the one taking care of mom, not my sister. And then I would be in the position to really potentially abuse my mom's finances. And maybe that court battle between my sister and I gets really mean and nasty because there's a lot of emotions involved in that. So my mom, by doing powers of attorney, avoids all of that. It is her, while she is healthy and able, making these difficult decisions, avoiding any sort of family conflict, and putting in writing with legal enforcement behind it who she wants taking care of her. And sometimes that's a difficult conversation, but people are surprised about the responses. In that very real conversation with my parents, I was a little bit surprised about what they wanted regarding their health care. And my sister was not. She was more on the same page as them. And sometimes you have to name somebody who is on the same page as you and going to be an advocate for you. So not having these documents can really result in a lot of legal fighting. And they're relatively cheap and efficient to get done as well. You might spend a couple $100s on a will and some powers of attorney, and that avoids months of either probate litigation or guardianship litigation, which oftentimes can take a couple $1,000s. So it is both less time consuming, less financially costly, and it avoids so much family consternation and fighting that nobody wants in their family.
So I have a question. I know you talked about a couple of different like powers of attorney, like there's a health powers of attorney and I guess more so the financial. So if you don't mind, I guess kind of discussing the difference or the importance of maybe having both.
Sure, sure. So they are two distinct powers, and we see that in the guardianship world as well. So somebody who doesn't do a power of attorney and they're left to go get guardianship, there is sort of the responsibility of the financial power of attorney or the guardian of the property if they didn't do one. And then there is the healthcare proxy or the medical power of attorney. And likewise, there is the guardianship of the person. So we have these two different roles: somebody to handle the money and the finances, somebody to handle all the healthcare decisions. It is very often that people may name the same person to have both jobs. They might name their, their sister, their brother, their spouse, whomever it is, but one person may have both jobs, but it is two separate authorities that you have there. The healthcare power of attorney, it's pretty obvious when that document is used. It's when somebody is incapacitated. They're in a coma somewhere. They have not just a diagnosis of Alzheimer's or dementia, but it's progressed to such a state where a doctor says they can't really comprehend the medical decisions that they're making. So in that realm, you have the medical power of attorney, or if you don't have that, the medical guardian or the guardian of the person stepping into that individual's shoes and making those very difficult healthcare decisions. It tends to generally focus on the end of life care, things like being in a persistent vegetative state or a coma, having an end stage condition where you're likely to pass away very soon, or a terminal diagnosis, something awful like ALS or metastatic cancer, where you may live with it for a little while, but there's no known cure. And going with that, whether someone wants to be on things like a ventilator or having a feeding tube placed in, or any type of procedures to prolong their life, being resuscitated, those types of decisions. So doing that healthcare power of attorney is giving that individual the authority, and then doing that advance directive with it is saying, these are what I think I would like, and giving them some information about how you want your healthcare carried out. And there's really no wrong answers to that. You have people on either end of the spectrum that say, please do anything and everything to keep me alive as long as medically possible. And people that say, please just leave me alone and allow natural death to occur, and everywhere in between. And there are no wrong answers in that. And you can include things like philosophical beliefs, religious beliefs, all of that is appropriate in that document. Stepping away to the financial power of attorney, it is much more clean cut of what we're dealing with, in that it is who's paying the bills, who's responsible for the investments, who's got the checkbook. If there's real property, do we need to sell the house? If there's a condo, do we need to sell the condo? Those different types of things. The part that has a little bit of nuance to that is when you make that decision, when do you want that person to act? You could say, I've always wanted to travel Southeast Asia or something like that, and I'm going on a trip, and I could tell my oldest daughter, you're in charge. Even though I'm healthy and able, I just don't want to worry about the mortgage while I'm gone. Or you could put some conditions in place, and that's what a lot of people choose to do. It may or may not be the right answer for each person, but a lot of people choose to put a condition that says, this document can't be used. My power of attorney cannot act until something medical has happened to me and my treating doctor signs off that I am not in a position to manage my own financial affairs. So that is why we have two of them. Sometimes people might name, the really fiscally responsible person in the family to manage the finances, and the nurse or the doctor in the family to make the healthcare decisions, or they might just name the same person to have all of that decision-making authority. And it really is a conversation between the family amongst themselves and the attorney and the client to say, what is the best fit for you, that hopefully you do these documents and you never need them. But if that unexpected stroke happens, that unexpected lightning bolt comes down and strikes you, who do we want to be in charge of making sure that we have things in place?
Okay, just curious too, on the financial front of the power of attorney document, would that give access to somebody to like their bank accounts? Is that something that we walk into like the financial institution with when we are, gaining control? Does that give us access? Is that what that document does?
Yes, that's exactly what that's intended to be for. So I have two daughters of my own. They're relatively young, but if I were to, be in a car accident or something like that and truly be incapacitated, and I had named my oldest daughter, she would take her copy of that power of attorney and walk into SunTrust, Bank of America, whichever bank I'm using at the time, and say, unfortunately, this happened to my dad. I need to be added to the checkbook so I can sign and write his checks or pay his bills or hop online and take care of those things. You do have the opportunity when you construct the power of attorney to limit it in some way. I could say, I trust my daughter to manage the checkbook and my investments, but I never ever want her to have the authority to sell the family beach condo or sell the family farm or do something like that. So as the individual creating it, you don't have to feel like I'm giving up all control and authority. You do have the ability to limit it to your comfort levels. But to your point, that's exactly what happens when those documents are needed. Some medical event happens, some diagnosis happens, and the responsible individual walks into the bank. Usually it takes 7 to 10 days or however long for them to process it. But you sit and you meet with the manager, they review it, they send it off to their corporate headquarters or whatever, and they get back to you and say, you now have the official authority to act. And one of the nice things about the state of Maryland is we really have some law behind it, and the certain forms that we use that banks, at least over a decade now, are used to seeing the Maryland form, and they process it fairly quickly, and they're required by law to accept it so long as it's filled out properly.
Okay, thank you for that. That's some good information. Now, what do we tell people or who say this, and this is something that I've heard, I don't have much to leave anyone, or I don't have anyone to leave anything to. What do they do?
I still think it's really important for those individuals to do a very basic will, because none of us can predict tomorrow and know exactly what we might pass away with. And particularly if you don't have any obvious heirs in terms of the traditional spouse and kids, it is all the more important to do that will and understand who you want to provide for and how that inheritance may impact them, no matter how big or small it is. The other thing that's important to understand with that basic will is what it actually applies to. I feel like a lot of folks have this false impression that if they do the will, it covers everything they own. And that is not always true. Things that pass outside of someone's will is something that is jointly owned. The terrible joke I make all the time is my wife and I, we jointly own our house. If I drafted a brand new will tomorrow that says I want that house, and I list the address and I say that house is to go to my girlfriend and I never want my wife to ever have it, and then I die the next day, my wife will be very upset to see that I wrote that in the will, but she still gets the house because of that joint ownership. So that joint ownership is always going to supersede a will. The other thing is direct beneficiary forms. If I write, hey, on my savings account, my oldest daughter is the direct beneficiary, and then I write in my will that I want everything to be divided equally amongst my girls, well, when I die, that oldest daughter is getting 100% of that little savings account because she was listed on the beneficiary form. So it's important to understand how the will applies and know that just doing a basic will avoids so many fights. Even if you don't think you have anything, as I said before, we see lots of people that aren't really fighting over the stuff as much as they're fighting over the emotions behind it. The relationship between parent and child, between siblings, between cousins, between grandparents, and saying, hey, even though, that China set isn't worth much, it has sentimental value. And you don't want people spending lots of money, time, and energy fighting over those things. And putting a basic will doesn't take a whole lot to do to put it together in Maryland, and it is worth avoiding all those fights, even if you don't think you have anything or really much to leave anybody.
So I know so oftentimes we see celebrities who haven't even had don't have a will as well. I remember people, oh, I found a will, yes, under the couch, and we've seen different um, cases where people, might have said something to someone, or they find something later on. Where should the will reside? Who really needs to be notified of the will? Can I just have it in my house and that serves as a personal legal document? What should I be doing with my will or with my information? Can I register my will? Like, um, provide us, enlighten us a little bit on that.
Sure, that is an excellent question. And there is what most lawyers say is sort of best practice, and then there's actually what the law requires. And what Maryland requires is a pretty low bar. They say we need the original document, all right, and we need to have 2 signatures on it from folks who do not benefit from the estate in any way, what they call uninterested parties, right? So 2 witnesses and the original document, and Maryland will honor that will. What most lawyers will tell you is probably best practice is to have that will notarized as well, because other states like Virginia require it to be notarized, so you may as well get it done. And because Maryland requires the original, keeping it in a safe place where people have access to it when needed. The best recommendation is each county has a register of wills where you can take the original will and file it with them. There's a very small fee associated. I want to say it's like, $3 or $4. It's not a tremendous fee. And what they do is they retain that original will in a sealed envelope, and they give it a filing number, and it is not opened or retrieved until someone shows up with the death certificate saying this person has passed, or that individual shows up themselves with their ID and says, hey, I'd like my will back, right? They've decided to make a change or something to it. And you can keep it there whether you move within the state of Maryland or whether you move out of state of Maryland, so long as you have a photocopy somewhere saying, hey, the original is with Upper Marlboro, Prince George's County Register of Wills. That is considered the best practice. Other people will store it in like a firebox or something like that within their house. The most creative one I've ever heard is people will put it in a Ziploc baggie and they'll put it in the freezer because the freezer's fire rated and everybody cleans out the freezer when somebody passes away. But the idea is you want somebody to have access to it. The one place that lawyers are very reluctant to have a client file a will is, or keep a will, I should say, is in a safe deposit box at a bank, because people end up in this circular battle with the bank and the courts, where the court says, we won't appoint you what we used to call an executor, now a personal representative. We won't give you that authority until you bring us the original will. And they go over to the bank and say, the court wants me to get the original of the will. It's in the safety deposit box. And the bank says, we won't let you in the safety deposit box until the court appoints you. And they end up going back and forth. And it does get resolved, but it takes a lot of time and energy. So that's the one place we say not a good idea to put it.
Thank you. Good information. So let people know where your will is.
Exactly. You don't have to show it to them. Don't tell them what's in there, but make sure that they have access to it. You say, hey, it's in the blue folder on the nightstand somewhere there where they know they can retrieve it should they need it.
So now, can you tell us what is probate, and is there a way to avoid it?
Sure. So a lot of people get uncomfortable talking about probate and they worry about probate. I might be a little bit biased, but I really don't think Maryland's probate is all that bad. What it is the process of the county saying the owner of this asset is gone. They have died. And we want to peacefully transfer this asset to the rightful owner by law. And we do that through the probate process, which is public. There are public notices of that. So we allow potential heirs to know what's going on. And they say, hey, we have all of these laws of intestacy to say who should inherit. But if there's a will, we're going to skip most of those laws and try to honor the will as best we can. Okay. So having a will makes probate go a lot more smoothly and a lot more quickly. people tend to associate probate with taxes, and that's not necessarily true. Maryland is one of 6 states that has 2 types of quote unquote death taxes. We have an inheritance tax separate from the federal government, and we have an estate tax. But most Marylanders don't pay them. And whether you avoid probate by doing something like a trust or something like a direct beneficiary form, those taxes still apply. They're pretty easy right now. Where we stand right now, Maryland's estate tax exemption is your first $5 million is exempt, so I'm never going to worry about it. And the folks that we usually leave things to, your spouse, your siblings, your children and lineal descendants, they're exempt from paying an inheritance tax. But what happens in probate is really the time that it takes and the opportunity for a creditor to file a claim against the probate estate. So I'll use the idea of sort of just a very simple savings account to give an example of how this works. If I list beneficiaries on my savings account and I say it's to go to my 2 daughters, somebody shows up to the bank, they give them the death certificate, the bank will then write up some cashier's checks and disperse whatever's in the savings account to my 2 daughters fairly quickly. It might take a week or 2 to process everything, but they will inherit that fairly quickly. They're not going to be subject to estate or inheritance taxes. If they were friends rather than children, they might be subject to an inheritance tax. You take that same bank account and you say it has to go through probate because I didn't list beneficiaries on it. Well, now that account the value has to be reported to the court, and it is subject to a 6-month period from the date of my death for a creditor to come in and say, not just mail me a bill, but file a claim in the court file saying, hey, he owed Visa $500, and before that savings account can be dispersed to the children, we got to get our $500 paid. The other thing that happens is the county may charge a nominal probate fee. It's usually not a lot of money, but they say, hey, there's a county administrative cost to make this process go. Most probate processes, if we're talking a regular estate, last probably about 7, 8, 9 months, somewhere in that range. And the big reason for that is we want to make sure that those creditor issues are resolved before we close the estate. So there isn't a tremendous cost to doing probate. Maybe somebody files a claim. Most creditors don't. But if they did, you'd have to resolve that. So most people worry about probate, and I tell them, we're not really worried about taxes. There might be a nominal probate fee from the county. And if you have a really big debt, they may try to attach to that probate asset. Can you avoid probate? Absolutely. The biggest ways to avoid probate are to do a trust where you transfer assets from your name to the trust's name. And because the trust survives you after you die, the trust is the owner of the assets and it can pass through the trust and it doesn't have to go through probate. Or you do things like on the smaller assets, you name beneficiaries on the retirement account, the savings account, things like that. And with married couples, they tend to own things jointly a lot of times. And so when the first spouse dies of a married couple, usually little to nothing is probated at all because of that joint ownership. So you can avoid probate. I wouldn't worry about it too much if you have to have a will that goes through probate. It's usually not the end of the world.
Okay, so that's good to know, like get that trust together.
Yes.
So give us the basics. What do I need to go ahead and get started with my real estate plan? What do I need?
I think most adults, really once you hit 18, it's not a bad time to think about this because tomorrow's not promised for any of us. And if you're a 20-year-old and you get hit by a car, you might want someone in your life to have medical power of attorney to make those decisions. So it's really never too early to start thinking about this. And what I tell people is however old you are, whenever you put the estate plan together, maybe every 5 years you pull it out of the folder and you take a look at it and make sure there's no big life changes. There's no weddings, divorces, deaths, childbirths, different people that you want to provide for in that estate plan. what I think the biggest thing you have to do to be prepared is really just a good mindset to ask the difficult questions. And whether that is having that dinner table conversation or a cup of tea with family members or something like that, and saying, I really don't want to think about death, dying, getting sick, and all that stuff, but I'm gonna, at least for a week or two, give it a little bit of thought. Always advise, maybe I'm a little biased here, but always advise, hey, talk with an elder law or an estates and trust attorney and say, get sort of the legal ramifications of what those decisions are and find the best way to put your plan in place. And so the big questions you'd have to ask yourself are, if I'm incapacitated, who do I trust to take care of things for me? All right. And then after I'm gone, who do I want to provide for? And who do I think is the most diligent person that's going to make sure that happens? Okay. It doesn't have to be the CPA or the lawyer in the family or the rocket scientist or whoever, just somebody that's going to follow through, that's going to take the documents to the bank, take the documents to the courthouse, and be diligent about it to get it done.
Wow, thank you. Whew, this is a lot to fill in through this time. We're about up with our time. But is there anything else or any tidbits you would like to give on estate planning? I know you would suggest someone going to see a lawyer, but is this something that somebody can start doing on their own, or any recommendations on that? I know that's a lot.
Sure. Absolutely. You can start doing this on your own. Maryland's Attorney General, you just Google the Maryland Attorney General website. They have some pretty good basic forms for both a financial power of attorney and for a medical directive. It's a good, easy way to start. It gives you some good questions to think about those things. You can do these documents on your own. I do really with the will more than anything else. I do encourage people to chat with a lawyer about it. There is a lot of different information online about different wills, and I've dealt with them. Some are good, some are bad. It is just hard to know until somebody's actually laying eyes on it and looking at it. But every state, whether it's Delaware, Virginia, Pennsylvania, Florida, we all have different quirks in our laws and how these things apply. And so I tell people it's fine to go online and start doing a little bit of homework on your own. But certainly before you sign on the line or make a firm decision, it's worth a couple bucks, or even find a lawyer that does a free consultation to have them look at it. And the biggest thing I tell people is feel empowered. Don't be afraid to do these things. I start working with people that are very nervous, and understandably so. They're facing mortality in a lot of ways, and they're very nervous about it. And by the time a week or two that we've worked with them and we're putting the plan in place, there is such a sense of relief that I've got a plan in place. God forbid something happens to me, I am prepared, and my family is prepared to take care of me in that instance. And they can say, I'm relieved, I'm done, I'm going to put it aside, and maybe I'll look at it again in 5 years or something like that. But that sense of relief that comes with knowing you're prepared for the terrible things that might crop up in life.
Thank you. Thank you so much. You said definitely a mouthful and gave us a lot of things to think about today. I thank you for coming on to the Golden 30 and letting people get an overview of what estate planning looks like, some of the different nuances. So definitely thank you for
Thank you,
joining
Carrie.
us.
I appreciate being here.
No problem. So if anybody, once again, if you would like to at least get in touch, we do, recommend Byrd and Byrd, and we thank them for allowing you to be here today. So thank you again, Tony Pasciuto, and you can reach Byrd and Byrd at byrdandbyrd.com. Also, we invite you to check out our free online resources. We have Gale legal forms available for Maryland, District of Columbia, Virginia, and federal forms for your wills, name changes, contracts, your power of attorney forms. So if you want to see a template of what these forms look like, please go through our website, www.p for Prince, G for Georgia, C for County, M for Memorial, L for Library, S for System.info. Long name, but great and powerful resources. We thank everybody for tuning in today. Please feel free to check us out on YouTube for some of our other archive programs. Thank you and goodbye.